Walter Echohawk. Presentation topic, Johnson versus Mcintosh and the Doctrine of Discovery in the United States. Impacts upon federal Indian law and the future of the doctrine under the United Nations Declaration on the Rights of Indigenous Peoples.
Good morning to each and every one of you. I want to thank the co-hosts for this important event, the Shuswap Nation Tribal Council, as well as Thompson River University, and especially my dear friend Arthur Manuel, Bonnie Leonard from the Tribal Council, and Kelly Connor for her help in getting me here today. And I want to commend the co-hosts of this event for putting together a very excellent program. I'm very honored and humbled to be a part of it with our distinguished speakers who are here today. And I'm grateful for your flexibility in moving me up forward into the agenda here because of my tight plane connection that I have. By all rights, I should be the least among the speakers. The other prominent scholars here definitely on this particular issue deserve to go first. So I'm very humbled by the opportunity to go first. I think that it's very important to have a dialogue and a discourse to critically examine the doctrine of discovery and the law of colonialism. This is a legal principle and a body of law that very much definitely shapes indigenous life in North America. It's very timely to have a conference on this subject because today in North America we stand at a juncture. We stand at a crossroads between two vastly different legal frameworks for defining indigenous rights. We have the existing legal framework that we live under that came to us from the law of colonialism. And we have a new framework that has been given to us by the United Nations in its historic endorsement of the UN Declaration on the Rights of Indigenous Peoples. This provides a modern legal framework for looking at indigenous rights in a post-colonial world. And we stand here in the 21st century at a crossroads, it seems to me, between these two legal frameworks for defining our rights as Native peoples. And so it's very timely to critically examine some of the foundational underpinnings of this old legal framework for defining our indigenous rights and perhaps navigating into this new human rights framework that has been given to us by the United Nations. And I think it's very fitting that we have a discourse of this nature right here in British Columbia, in Canada, because there is currently a pitched battle that is going on for indigenous rights in this province. And I think that it is good for this university and this the co-host to give us a little opportunity to pause from that struggle, maybe step back away from it for a little while and take stock as to where we are and see where we can go from there, looking at the big picture of the fundamental nature of our legal rights as Native peoples. And so it's very fitting that we have this discourse today right here in British Columbia. And so I want to extend my very respectful greetings to the tribal chiefs that are here today, our elder who offered that wonderful song and blessing this morning, to you tribal leaders that represent the First Nations of Canada that are represented here today, with special respects to the elders that are here. And I bring you my well wishes from the state of Oklahoma, where I live, and my prayer that the Great Spirit will be with each and every one of you in your struggles today and as you go forward in your important work on behalf of your peoples. And I'm very glad to be a guest in your wonderful, awesome homeland here in British Columbia. I am a Pawnee Indian from the state of Oklahoma, where I practice law, as was mentioned earlier. Our law firm represents a number of Indian tribes in Oklahoma. There are 39 Indian nations in Oklahoma. I think we may have the largest Native American population, or American Indian population, in the state of Oklahoma. If not, a close second to California. But we represent, for example, the Legislature of the Cherokee Nation, excuse me, from time to time. This is the largest nation in the United States, Indian nation in the U.S., with a membership of over 200,000. We serve as general counsel to the Comanche Nation, the Lords of the Plains, a tribal nation with 15,000 Comanche tribal members, a full-service tribal government, and about 10 other Indian tribes and tribal entities and organizations within our state of Oklahoma. I have no international law experience that I can share with you today. And I don't have any knowledge of Canadian law. I need to tell you that right up front. I haven't had the opportunity to read your cases, so I'm not familiar with the nuances of Canadian law affecting Indigenous peoples. My practice as a native rights attorney since 1973 has been focused on the domestic law in the United States, just about exclusively. I did come to British Columbia to represent the two Kootenai bands, the lower Kootenai bands of British Columbia in a 5-year judicial proceeding in Montana to protect one of the Kootenai holy places located in the Kootenai River there. But beyond that, I haven't done much legal work up here in Canada, and so I'm not here to provide you with legal advice. You know, for legal advice and political strategy advice, you'll have to consult your own attorneys, your own leadership, your own strategists, you know, for advice on particular matters. I can't give you that. But I can share the perspective that I have individually as a longtime practitioner of federal Indian law in the United States. And my personal perspectives might be possibly one useful source of information to you as you chart your course for the future and navigate the big issues that are confronting you here in British Columbia. But in my talk, it's going to be my premise today that it's very timely, as I mentioned earlier, to critically examine this doctrine of discovery as it exists in North America today. And there's many reasons to do that at this time. This is at bottom an unjust legal principle that continues to shape Indigenous life in North America, both the United States and Canada. And it serves to be one of the foundational legal principles for defining our political rights and our land rights in the United States and probably up here in Canada as well. This is a legal principle that was brought to North America by Europeans and used by them to define their relationship with the native peoples of the New World. And it is a foundational legal principle or a legal doctrine for the existing legal framework for native rights in the United States, and that's that body of law called federal Indian law. And likewise, I suspect that the Doctrine of Discovery is also very important up here in Canada, in the Canadian legal system as well. This doctrine has had for many, many decades, if not centuries, a pervasive impact on the law. It's left a big footprint that endures to this very day. In the United States, native peoples, American Indian tribes and Alaska Natives have lived with this doctrine of discovery for many decades, and we've really tried to make the best of that doctrine or that existing legal framework for many decades in this modern era of federal Indian law. And I think to our credit, our tribal leaders in the United States and our legal advocates during this modern era since 1970, we've made many striking nation-building advances in the United States on behalf of Native people, despite this doctrine. But the fact remains that a people can only go so far under an unjust legal system. You can only advance so far in your social aspirations under an unjust body of law. And at some point, our movements for human rights and indigenous rights will surely stall out, perhaps at the very doorstep of self-determination, or stall out at the doorsteps of justice under an unjust legal regime. And there will come a time when, rather than live with and cope with and make the best of an unjust legal regime, we have to confront that legal regime and change it and move into a different legal framework. And I think that today we can look out and we can see that brand new legal framework for defining indigenous rights in North America. And it comes from the United Nations Declaration on the Rights of Indigenous Peoples. It provides a human rights framework for defining indigenous rights, which is, in the United States at least, a brand new concept to look at native rights as inherent human rights. If we look at our case law in the United States and our statutes and policies, there's no discourse about human rights that can be found in the body of federal Indian law. The landmark cases eschewed abstract principles of justice when defining the nature of Native American rights. And you can read the cases, and you cannot find any discussion by the courts of human rights when it comes to Native American rights. And so this is a brand new framework. The notion that we may have human rights, that self-determination, the right to culture, and all of the bundle of indigenous rights that we have, land rights, habitat rights, rights to territory and resources, tribal sovereignty, self-government, language, indigenous institution, are inalienable human rights. And by defining them as inherent rights, it means no nation can ever take them away from us because they're inalienable rights. Well, that's a brand new way of looking at Native rights, at least in the United States. And I think that this UN Declaration presents a more just foundation for Indigenous rights than the rights that arise from the old body of federal Indian law. Federal Indian law and the rights that arise in federal Indian law come from a 19th or 18th century foundation of colonialism based on notions of discovery, conquest, plenary power, unfettered guardianship, ideas of racism and European ethnocentricity. These set of values are outmoded, but they are the ones that gave rise to Native American rights found in federal Indian law. And any body of rights that rest on that dark foundation are necessarily vulnerable rights. Whereas the new foundation for modern Indigenous rights that come from this declaration rest on notions of justice, equality, non-discrimination, good faith, and universal human rights, which is a very strong foundation, a much more strong and a much more just foundation for Indigenous rights. And so these are vastly different legal frameworks that we're looking at here. And I think that the paramount challenge is for our people, we who are living today in the 21st century, is to stride towards that new framework for Indigenous rights, that we might enjoy our Indigenous rights as human rights and stand in the light of justice. It's important that we do that and our non-Indigenous neighbors do that so that we can all repudiate this legacy of colonialism that we inherited from earlier generations of a bygone era and take the necessary remedial steps to enter into the light of justice, that we might all stand there together as one people's, living on the same land. So the purpose of my talk in the time that I have available here, what I would like to do then is basically two things. First, I want to review with you the old framework, in the United States at least, for defining Indigenous rights, the legal framework for federal Indian law, as we call it in the U.S. And I wrote about this legal framework in my book that might have been referred to, In the Courts of the Conqueror, where I study the dark side of federal Indian law, some of the nefarious legal doctrines that taint federal Indian law that have come to us from the law of colonialism. So I want to examine that framework with you for a little while. I want to look at Johnson v Mcintosh, which is the infamous Supreme Court decision of 1823, where the Supreme Court adopted this Doctrine of Discovery and made it, even expanded that doctrine and made it a cornerstone principle of domestic federal Indian law in the U.S. I want to take a minute and look at that case with you. And then I want to look at how Native Americans in the U.S. have really tried to live with that existing framework in the lower 48 during this modern era of federal Indian law, where we tried to make the best of what was given to us by the law. We didn't assault the law or conduct a frontal assault on some of the nefarious legal principles, but we tried to focus on the protective side of that body of law and coax the courts to apply the protective features of federal Indian law in a modern day context, much like what the Black America did in trying to live with the legal doctrines of Plessy v. Ferguson, that separate but equal doctrine in the United States, where NAACP was formed in the year 1910 and wanted to overturn racial segregation in the United States, and Plessy v. Ferguson, this separate but equal doctrine. Well, their legal strategy was basically to live with that legal framework for the segregation and try to make the best of it. So they litigated throughout the country for several decades to actually enforce Plessy v. Ferguson, the separate but equal component. They focused on that equal component all the way up until 1950, and when they finally decided we need to do a frontal assault on the law of racial segregation. And so they turned their target to the law of racial segregation itself and sought to have it struck down. And so I want to look at the parallels there that we have as far as what we've been on a similar track in the U.S. And then secondly, I want to take a look at this new framework for Indigenous rights. I do have a book out that is in press right now. It's entitled In the Light of Justice, that examines this new legal framework and how we might implement it in the United States. This book will be out next June, so I hope you'll get a copy and get a chance to read it. But I want to look at this UN Declaration on the Rights of Indigenous Peoples, which has roots in modern international human rights law, and how it repudiates and rejects Johnson v. Mcintosh and the Doctrine of Discovery. And in fact, if these standards in this UN Declaration were the law of the land back in 1823 when Johnson was decided, and the U.S. Supreme Court had to apply these standards to resolve that case, we would have had a vastly different outcome, and we would have no doctrine of discovery in the U.S. had the Supreme Court back then had to apply these standards as the law of the land. And then I want to look at some of the challenges that lie before our generation to implement this UN Declaration. That is, to move away from the law of colonialism that is found in federal Indian law to a human rights framework. Realizing that as we stand here today, this UN Declaration is not a self-executing treaty. It has no binding legal authority. It has to be affirmatively implemented in North America by Native people in cooperation and collaboration with the governments of Canada and the United States. So let me talk a little bit then about the old system of federal Indian law in the United States. We have to look at this body of law through the lens of colonialism, European colonialism. As we know, colonialism was the predominant social order in the world from 1492 all the way up to about 1960. A 4.5 or almost a 500-year period when the nations of Europe competed with one another to colonize, conquer, and Christianize as much as the rest of the world as humanly possible. And so in this 500-year span, All of the Western Hemisphere was colonized. All of the circumpolar world was colonized. Africa, Australia, most of Asia, most of the islands in the Pacific were colonized. This was a universal, worldwide phenomena. And it involved a one-way transfer of property from indigenous hands to non-indigenous hands in each and every colony around the world. This was a very harsh, life-altering experience for indigenous peoples, not only in Canada and the United States, but around the world, because it invariably meant the invasion of their homelands, the appropriation of their properties and natural resources, the destruction of their indigenous habitats, the destruction of language and culture, warfare, disease, and even acts of genocide and ethnocide and ecocide as defined by the United Nations. So this was a very harsh, life-altering experience for Native peoples around the world. And it gave Native peoples a common fate, a common history, and a common set of aspirations for protecting their ways of life from the ravages of colonialism or the harsh impacts of colonialism. Was colonialism legal? Yes, it was legal according to the law of the colonizing powers, the law of colonialism, which came to us by early international law. It supported this colonialism effort and made it perfectly legal, attempted to justify and legitimize acts of colonialism throughout the world. And so the purpose of the law of colonialism in international law was basically threefold. First, and I hope that some of our other speakers will talk about this further, but it governed the relationship among the nations of Europe as they went out on the international plane to colonize the world. Secondly, it set forth the rules for colonizing non-European nations through doctrines of discovery, notions of plenary power, guardianship, Christianization ideas, notions of race and culture. But these rules and this body of law were not accountable to indigenous peoples. It acted as a tool to strip them of their rights. And contained no protections for indigenous peoples at all during the lengthy history of international law, this body of international law, up until a couple recent decades ago. But the third purpose of this body of international law was to basically to justify and legitimize acts of colonialism on the part of European nations. The attributes of this body of law, especially the special attributes that relate to indigenous peoples, we can see that first and foremost in the subject of this conference, this doctrine of discovery, doctrines of conquest, the just war doctrine, the use of violence or military force against indigenous peoples, notions of trusteeship, guardianship principles, notions of racism, notions of plenary power. These are all integral components of the law of colonialism. And it was this body of law in various forms was embraced in each and every colony around the world in different formats or whatever, but the basic fundamental principles were embraced worldwide and are still seen today in many of the progeny of the original colonies in the settler states, and the imprints in the legal systems are still there. But there came a time in history after World War II when colonialism was repudiated by the international community as being an unjust institution. And in the decolonization movement after World War II, many of the last remaining colonies achieved their independence. In 1960, the UN passed a decolonization resolution that formally condemned the institution of colonialism and asked the colonies to transfer power back to the Aboriginal areas there. And so this institution has been repudiated on the international plane, but its legacy has left marks on many domestic legal systems, including that in the United States and probably here in Canada, which I think is still a colony, isn't it? Legally or technically, we owe our allegiance to the Crown. But this long-standing institution and body of law has had a major impact, a major influence on federal Indian law in the United States. Federal Indian law is that body of federal law that defines the rights of American Indians and Alaska Natives in the U.S. And there's 8 sources of federal Indian law that comprise federal Indian law. It's international law being one source, as I've just described to you. The second source are the treaties. We got 360 treaties in the U.S. with Indian nations. The third source of federal Indian law is the U.S. Constitution, refers to 4 forms of government: foreign nations, the central federal government, the states, and Indian nations. Supreme Court decisions are the 4th source of federal Indian law. The 5th is acts of Congress. The 6th source are executive orders promulgated by the president. The 7th source is administrative law, or the rules and regulations of the federal agencies. And the 8th source is tribal law, traditional laws and laws passed by the Indian nations. But our courts adopted a lot of these principles of international law in the early days of the Republic in the United States. The whole idea of treaties was imported directly from international law. The doctrine of inherent tribal sovereignty was an international law principle. The Protectorate doctrine of Worcester v. Georgia, to the relationship between the U.S. and the Indian nations, is like a protectorate designed to protect the well-being of the Indian nations as they came into the Union under the treaties. This ideas of guardianship and trusteeship came directly from international law and was adopted in whole cloth in the United States. Notions of conquest and discovery, as well as plenary power, the plenary or absolute power of Congress over Native people. All of these principles came from international law. And so international law has had a major source on the development of federal Indian law. Johnson v. Mcintosh was decided by the Marshall Court in 1823. And in that landmark case, this was the first case that went to the Supreme Court involving a significant Indian issue. The Supreme Court, under the leadership of Chief Justice John Marshall, ominously described the federal court system as the courts of the conqueror. And that is a very scary description. Makes you wonder how Indians would fare in the courts of the conqueror. But after donning the robes of the conqueror, the Supreme Court went on to define land rights for American Indian tribes. And in that course, adopted this doctrine of discovery, and in fact expanded that doctrine a bit, shaped it for the unique American setting. And in a nutshell, the court held that the act of discovery by British explorers operated to transfer legal title to Indian land to Britain, and then on to the United States as its successor in interest, leaving the tribes only with a right of occupancy. A right of occupancy that could be extinguished at the will of the government, either by purchase or by conquest. Of course, the impact on the tribes of this rule of law was they went from landowners to tenants of the government with a right of occupancy. So it seriously impaired Indian land rights in the United States and set the stage for enormous land loss among our native peoples to the south here. And we found out that this right of occupancy that was left to the tribes was not even a property right at all, according to the Supreme Court in 1955 in the Tehatun case, Tehatun versus United States. The Supreme Court said that this aboriginal right of occupancy does not even amount to a property right that is a compensable right under the Fifth Amendment to the U.S., so that Congress could take it without even confiscating the tribal lands without compensating them. The second thing that this ruling did was it equated the right. It equated discovery with conquest. In other words, that the act of discovery was tantamount to conquest as well. Both of these are being legal fictions because neither one of them was true as a matter of fact. You know, the act of discovery does not amount to a sale of property, nor does it amount to the conquest of tribes. And many of our tribes in the United States, as you well know, were ferocious and capable of defending their land, such as my Comanche clients who barred settlement of the southern plains for over 150 years. So this rule then, rule of law that of the Supreme Court became then the source of land rights in the United States, of real property ownership in the United States. It's still the law of the land today. It's never been reversed. And it's given rise to a dark side to federal Indian law. The progeny of this case, there's a line of train of judicial thought there relying on the law of colonialism. That amounts to a dark side to the law in the United States. My book, In the Courts of the Conqueror, there's a chapter that analyzes this particular court decision, but it's really one of the most outrageous cases ever decided by the American courts. there were 4 factors that were at play there. The first one is that the whole case was tainted by bad ethics. Judicial conflicts of interest, attorney conflicts of interest. The real parties of interest were not even present in the litigation. It was a feigned controversy. There was no real case or controversy. It was a made-up case where the plaintiff land company chose the plaintiff, chose the defendant, hired the defendant's attorney, paid the defendant's attorney, paid that attorney what to say, went before a federal trial judge that was relative to the family of the plaintiff land company, and when it got all the way up to the Supreme Court, they did the same thing, hired the opposing counsel, told the opposing counsel what to say, and it went before Chief Justice John Marshall, who owned 240 square miles of land near the case area. The Marshall land empire and family fortune depended on the outcome of that case. All of these are, according to modern ethical standards, heavily taint that proceeding. And those factors are ingredients for a miscarriage of justice. And that's exactly what happened in that case. And I think that case, it doesn't stand for a rule of law handed down by God himself, as many seem to believe, but it was crooked as a barrel of snakes. And the second force at work in that case was the forces of racism. When you read the opinion, both the plaintiff and the defendant, as well as the court, referred to Indians as an inferior race of people, savages with inferior characters, cultures, religions. And this was something that would never be allowed in a modern courtroom, to use race. And if you read the opinion where the same paragraph where the court decisions are decided, you'll see these racial descriptions, standard classic race descriptions of racism. Third, the forces of economic greed for Indian land were the overarching factor here. And finally, the forces of colonialism. So, my conclusion on Johnson v. Mcintosh is that this case needs to be overturned by this generation of attorneys, of litigators in the U.S. It gave rise to a whole dark side to our body of law. It makes our rights vulnerable today, and was not handed down by God himself, but was very heavily ethically tainted proceeding. And John Marshall himself, 1 decade later, in Worcester v. Georgia, rejected this doctrine of discovery as an absurd doctrine and circumscribed the scope of this doctrine. Unfortunately, a year later, he passes away, and the Andrew Jackson Supreme Court rapidly reinstated the doctrine in 4 or 5 Supreme Court decisions. But John Marshall got it right. This is an outlandish legal doctrine. It's absurd. It's based on legal fictions. The misuse of legal fictions. A legal fiction is a tool to try to strive for a just result, as we see in cases of, say, a constructive contract in the case of fraud, but shouldn't be used as a tool to getting an unjust end, which is how it was used in the Johnson case. Can this decision be overturned? I think it can. But it looks like a 500-pound gorilla, and it intimidates our litigators back home. So we try to live with it. But we can look to the NAACP and their efforts to overturn Plessy v. Ferguson, that 1896 Supreme Court decision that injected this law of racial discrimination into U.S. law. It took 40 years, but when the stars were aligned and when they finally got the wind at their back, they overturned that Supreme Court decision in Brown v. Board of Education. And so I think that we can do that on Johnson v. Mcintosh, because this UN declaration that I mentioned earlier abhors doctrines of dispossession. Notions of racism in any form are strongly condemned. Land rights are to be respected in this UN declaration. So it would cause John Marshall to roll over in his grave. And if his court had to apply these standards in that case, it would have had a totally different outcome. And so despite this, I just wanted to, before I leave here, talk a little bit about this our modern era of federal Indian law. As I mentioned earlier, since 1970, great strides have been made in the United States, nation-building strides, under this legal framework of federal Indian law. And that's been our legal framework in the United States. And the basic strategy there was not to attack federal Indian law. We accepted that body of law, but tried to coax the courts into adopting and applying the most protective features of that body of law, the inherent tribal sovereignty doctrine, the Protectorate principle, enforcing the treaties. So we just basically, during this period, have tried to make the best of that legal framework. But as I mentioned, you could only move so far under an unjust legal regime. And in the United States, at the present time, the Supreme Court is on a judicial trend towards trimming back our Native American rights. Since 1985 to the present day, we've lost over 80% of our cases before the U.S. Supreme Court. And in some terms, we've lost as high as 88% of our cases. That statistic means that Indian nations fare worse in the Supreme Court than prison inmates, have a better track record there. And it's led a number of our leading legal scholars and worried tribal leaders to ask, is federal Indian law dead? So we have stalled out, in my opinion, at the very doorsteps of justice because of this dark side of federal Indian law. And we haven't been able to stride into the light of justice yet because of this dark side of this legal framework. We need to strengthen it, and that's our challenge in the United States. And I think that this next generation is going to have to be looking at this UN declaration and working to implement it, to elevate federal Indian law so that it comports with each and every minimum standard that is laid out in that Declaration of Human Rights. And so with the minute or two that I have left, let me turn to this new framework, if I can. And maybe just ask a quick question here. Raise your hand if you've read the UN Declaration on the Rights of Indigenous Peoples, if you've had a chance to read it. At least half the room has. That's very good, because in the United States, only a couple hands would come up if I asked that question in the lower 48. Indian country, mainstream Indian country, is just now starting to read this UN declaration and learn about it. Most of our leaders and most of our tribal attorneys, including myself, were focused over the last generation on our domestic law in our own backyard, and we didn't have the vision to go to international law. Only a few of our pioneers went into the international arena. Many of them are going to be here. But this is a UN declaration. It was 30 or over 20 years in the making. It lays out minimum standards for protecting the survival, dignity, and well-being of the world's indigenous peoples. It borrows from existing modern international human rights law and applies that larger body of law and interprets and applies it to the indigenous context so that indigenous peoples will have the same human rights as enjoyed by the rest of humanity. It addresses the full range of indigenous rights. All of our political and property and treaty and habitat and human rights, self-government, self-determination rights are addressed in that document. And as I mentioned earlier, it's based not on nefarious notions of racial discrimination and conquest and discovery, as if we were an abject British colony, but rather it focuses on a more just foundation based on justice and human rights, equality, good faith, democracy. And it's a remedial doctrine, a document that is designed to address and provide reparations and remedial justice, for this legacy of colonialism. It gives us an opportunity to have a dialogue with the larger society, a discourse about the nature and content of human rights for Native peoples. Even though right now it's not a legally binding document, it holds enormous promise, in my opinion. And we have to bow to the indigenous pioneers that went to the UN for several decades to get this thing passed. But it promises to do nothing less than change the world, to change the way that the world looks at Native peoples around the world and in our own nations here. It opens a new era of indigenous rights. It allows us to define indigenous rights as inherent human rights. These aren't rights that were given to Native people. It's rights we already had that came from our cultures and our ways of life. Being inherent means it's an inalienable right, i.e., it's larger than a nation. No nation can take that away. That's what our Declaration of Independence tells us, that the purpose of governments were formed to protect and promote inalienable human rights. And so this body of rights is an amendment to that. And so I think that the Johnson case would not pass muster under that set of standards. It allows us to open a new pathway to move from the law of colonialism into the realm of human rights, where I think we belong. It allows us to take stock of our progress as Native people and as nations, and how well we have incorporated Native peoples and their rights into the body politic, and to have a dialogue about the true nature of indigenous rights as human rights. And so with these remarks, then, I think I would just leave you with two things that We do stand at a crucial time in history, at the juncture between two legal frameworks. We have great opportunity to stride towards the modern framework, or maybe pick the best features of both and craft our own legal framework. And I think that to realize the challenges of this UN declaration and attain the aspirations that were out of beyond reach by our forebears, our paramount challenge in North America is to implement this UN declaration. And I think that that task, that great journey, that adventure deserves the highest priority by our Native leaders, our attorneys, our scholars, our law students, the larger society, Canadians and Americans of goodwill, so that we might all stand in the light of justice. In the United States, we've just begun. We've just begun. I think there's been a Senate oversight hearing to begin looking at the implications of this landmark declaration. A couple months ago, the UN Special Rapporteur, S. James Anaya, conducted an official visit to the U.S. with the to identify barriers in the U.S. and provide recommendations to the U.S. on how to implement this declaration. That report just came out this month, and Indian country is girding itself by reading this declaration at this time. But yet there's no national coordinated movement that has been set in place yet to implement it. That's the challenge before us, it seems to me. And I think that it would be a transformation of the way that America looks at Native American rights. And so it's my hope that our tribal leaders in the United States and our tribal attorneys and civil society will rise to that challenge and promises of implementing this document. I had nothing to do with the making of it, but I watched it being made from afar, thinking that it was a landmark development. And indeed, I still believe that today. And so with these remarks, I want to again thank you for my opportunity to speak. Again, my well wishes that Canada may one day stand in the light of justice. Thank you.